the shooting that happened, in the manner in which it happened, from all of the different angles, is certainly probative to the aggravating factors, and I do not find that there's any unfair prejudice to the defendant.
Welcome back to Court TV Live. I'm Judge Ashley Wilcott. Thank you for joining us this afternoon. Nikolas Cruz's defense team seems to be having some difficulty getting their motions through with Judge Scherer and allowing multiple pieces of evidence in the tragic shooting at Marjory Stoneman Douglas High School. Judge Scherer has respectfully ruled her court during a very difficult and emotional trial. But even yesterday, evidence admitted in seemed to leave the judge shocked. During the testimony of a survivor of the mass shooting, video was played in court of the day of the shooting with sobs for help echoing loudly through the court speakers. Judge Scherer has handled the emotional content that the jury has to hear to determine life or death for Cruz with poise. Yesterday, the judge allowed one witness to leave while her video was played in front of the jury so that she wouldn't have to relive that tragic day.
Ladies and gentlemen, we're going to continue the video that you have just begun watching, but we excuse the witness so that you would not have to watch herself being injured. But it is part of the same video. Mr. Schatz, whenever you're ready.
Thank you.
On the first day of trial in this case, the gallery was packed with families and friends of the victims of the shooting. During one of the audio recordings, a member of the gallery emotionally spoke, asking to stop the audio of that shooting being played in the courtroom. Now, of course, this led to the defense asking for a mistrial.
First of all, my desk is elevated, and I could not see who was speaking because the person is in at least the 6th or 7th row, which I would say is at least 150 feet from the bench. That's number one. Number two, I couldn't hear what the person said. In the abundance of caution, I asked the white noise be put on. But somebody shouting one thing when you don't see them or you can't hear exactly what they're saying is not even close to grounds for a mistrial. The jurors, I don't even think any of them looked. As far as the volume being on the loudest volume possible, that's not grounds for a mistrial. I asked the state next time, turn it down a little bit, but so that people can see it, but your motion's denied.
During difficult testimony, Cruz may be attempting to garner sympathy by putting his fingers in his ear. Cruz has been seen at times plugging his ears to drown out the sound of evidence being presented. Should Judge Scherer be addressing this behavior with Cruz's defense counsel? Let's discuss this with our legal analyst in today's From the Bench. Still with us in Baton Rouge, Louisiana, criminal defense attorney Franz Borghardt. Let me just start with this. What do you think of Judge Scherer's demeanor throughout this trial so far?
I don't disagree with her rulings. Is some of her tone, is some of her mannerisms somewhat reflective of maybe being state-oriented? Maybe, but I don't think she's ruling incorrectly. I think anything can create an issue on appeal during a penalty phase, assuming the jury comes back with a death verdict. So, if I were playing armchair judge, I would say you need to appear a little bit more neutral in your tone and your mannerisms. But in terms of her rulings, Judge, I think she's doing just fine. There has been a question about, is letting too much come in going to create an appellate issue because it's prejudicial? Well, the fact of the matter is that to prove aggravating circumstances, all the evidence is going to be prejudicial to the defense because it's going to point towards a death penalty. So for now, at least, I think the judge is good. But again, she just needs to be mindful of creating issues, because the last thing anybody wants is for this process to have to be repeated and for these victims to have to go through this all over again because an issue on appeal overturns a death penalty.
Right, and so the death penalty is one that we know would be appealed by the defense. Now, if he gets life in prison, we know that there's nothing the state can do about that. So the prosecution cannot appeal that, and it would end there. But she was a former prosecutor, Franz, so I think that, to your point, maybe that does affect her demeanor, her tone, her delivery. Don't know if that's why, but we do know that she was a former prosecutor. But let's also talk about this. I really appreciate of any judge that they are very clear, putting on the record what their decision is and the reasons for it. And she does that very consistently every time. And when someone appeals, that's the most important piece of it. But having said that, I have to ask you this. You're a criminal defense attorney. You have a client seated next to you that you have trauma to victim after victim after victim after victim in that courtroom, some of whom are sitting in the gallery the entire time, and you watch him consistently with his head in his hands, plugging his ears so that he doesn't have to listen to what he caused, even though everybody else in that courtroom can hear it. Is that reasonable? Is that okay for the defendant to be allowed to sit like that during court with the jury watching him?
So your question has a lot of different answers. One, the question is that something that the defense attorneys can even control? Have they told him not to do it and he's still doing it? I mean, because ultimately at the end of the day, Judge, I can't affect the body language of my client who's sitting next to me during a trial as much as I really, really want to. Second of all, and I alluded to this in the previous segment, look, there is no right posture and body language for this convicted defendant. If he doesn't show emotion, then someone's going to say he doesn't care. If he looks at the victims while they're testifying, someone is going to say he's trying to intimidate these individuals. If he puts his hands or his fingers in his ears and looks down, someone is going to have a problem with no matter what this defendant is doing during the presentation of evidence. And let's just be honest with each other. It was very difficult. It was very difficult to listen to the recording of the actual shooting. And that was just for us listening to the audio. There's no telling what it was like to watch it in real time in the courtroom. So is it appropriate such that the judge should step in? I don't think there's enough yet for her to do that. And secondly, it's it's not testimonial. He's not testifying. It's just the way he is sitting and perceiving the evidence being presented.
Well, let me give you my take from the bench. There's so many different aspects to this. I completely agree with you. Who knows what the attorneys have said to him or not said to him? Who knows if he's able to control it with any mental health concerns that may exist with him? But on the other hand, the judge is responsible for keeping the decorum of the courtroom. And I think what it would turn on if I were on the bench is whether or not his behaviors are a distraction to the jury. We can't see the jury and what they're doing and how they're reacting. But if I were the judge and if a jury were always focused on that, looking at him, paying attention to what he's doing, reacting visibly in any way to what he's doing, I think that I would have at least an off-the-record conversation with all of the attorneys in chambers to say, look, he's a defendant. He can react to the evidence the way he chooses to, but it's become a distraction, in my opinion, because ABC, and then address it in that manner. Of course, I don't know how the jury's reacting, but I think it is something to keep an eye on. Always love your expertise. Thank you for